morning, everyone. We would like to welcome you all to our webinar on the new CCDC 2 2020 contract hosted by FCA Insurance and WeirFoulds LLP. My name is Andrew Cartwright, and I'm the Vice President of Surety at FCA Insurance, and I'll be your moderator today. Joining me is an esteemed group of panelists, and in no particular order, we have Krista Chater. Krista is an experienced litigator with a practice focused on business litigation. Krista has experienced litigating a large number of business disputes, including those related to commercial leasing, construction, real estate, shareholder rights and remedies, and employment. Farron Bogach is a partner at WeirFoulds LLP and is an experienced litigator with a practice that focuses on construction and infrastructure. Farron has significant expertise helping clients navigate through a broad range of complex disputes. She works with clients from across the construction pyramid, including owners, contractors, consultants, subcontractors, and trades, and she has experience with project strategy as well as lien, contract, procurement, professional negligence, and delay claims. Jeff Scory is an associate at WeirFoulds LLP in the construction practice group with a practice that focuses on drafting and negotiating contracts and advising on other front-end aspects of construction projects. Jeff has experience reviewing, negotiating, and drafting all manner of construction contracts, including design build, construction management, EPC, development, consulting, and supply agreements. His clients include public and private owners, developers, contractors, subcontractors, suppliers, and consultants. Last but not least, we have Jamie Collum, the Vice President of the Construction Practice at FCA Insurance. Jamie specializes in procuring and managing and advising on construction insurance and bonding for clients from across the construction spectrum, ranging from general contractors to civil contractors and all classes of subtrades. Jamie is a regular contributor to the Daily Commercial News as a co-author of the bi-weekly Surety Corner column, and Jamie has also delivered numerous seminars and presentations on construction bonding and general industry updates across Ontario to various construction associations. Before we kick off, just a few quick rules of engagement. You'll notice at the bottom of your screen, there's a Q&A button. Throughout the presentation, if you have any questions, please enter them there, and we'll answer those at the end of the presentation. If you have any other inquiries outside of that, please use the chat box. And with that, I'll pass it over to Jeff. Take it away.
Thanks, Andrew. So hi, everyone. It's great to see so many of you joining us today. So in terms of what we're going to cover today, we're going to start off with a brief overview and reminder about what the CCDC 2 contract's all about. We're then going to talk through the various changes of the new CCDC 2 2020 that you should be aware of. So some of the key things like changes to the payment terms, what this new concept of ready for takeover is, what are the new insurance requirements, and some of the other big ticket items that should be on your radar. We're also going to briefly explain what the new Division 1 document is, this new specification document that CCDC prepared and has released alongside the new CCDC 2 2020. So we're going to provide a brief explanation of what that document is, when you can expect to see it, and why you should be familiar with it. We're going to briefly talk about what to expect to see with regards to supplementary conditions going forward. And lastly, we're going to discuss some general best practices when it comes to contracts, contract documents, contract management, and then we'll cover some questions. And I also just want to make a quick shout out to our sponsor for this presentation, which is Payprompt. Payprompt is a software that helps you manage and track the various deadlines under the new prompt payment rules that came into force in October of 2019 under the new Construction Act. So it tracks the deadlines for when you have to pay, when you can expect to get paid, when you have to issue notices of non-payment, and it provides all the various forms for you to fill out and you can send right there on the spot. And it sends out notifications and deadlines to you and whoever else on your team you think need them, and it diarizes them in your calendar. So it's a great, easy to use tool that efficiently manages the new prompt payment rules for you. And it's available to owners, contractors, subs, everybody in the construction pyramid. So thanks to Payprompt, and go check them out. And with that, I'll pass it over to Krista.
Okay, so I'm going to start. Hi, everyone. I'm going to start with just an overview of the CCDC in general and the CCDC 2. We need to go ahead one slide. Who's in charge of the slides, Farron?
You should see the CCDC suite of contracts. Is that not up there?
We do not. Oh,
Okay.
7
Why don't
minutes.
you start
in.
and I'll get it working again. Sorry about that.
Okay, let me ad lib on without the slide. So the CCDC, many of you will know, it's really not just one contract. It's a whole suite of contracts. There's a whole bunch in the suite that the committee has put together. But the CCDC 2 itself, that's the stipulated sum, the fixed price contract. The CCDC 2 is sort of the cool kid. Everybody uses it. Everybody knows it. It's the cheerleader. It's on the hockey team, et cetera, et cetera. That's the one everybody knows and loves. That's the most commonly used, and that's why it's been updated first. But there's also a bunch of others, and depending on how you perform or what you perform and how you do your projects, you may be familiar with the other ones too, like the cost plus or a design build or unit price. And there's an expectation and an intention that all of these are going to be updated sort of to speak to the same issues that the CCDC2 was updated for. So keep your eyes open for those. It's not done yet, but we expect it will be soon. We know you've lost the PowerPoint. Thanks for letting us know. Farron is scrambling in the background to get it back up. And in the meantime, we will, I'll just speak to what is on the PowerPoint. Luckily, the first few things are not that the PowerPoint's not good, but you don't need it for the first few things. So what's the basic project structure for the CCDC2? It's your typical project structure where you have an owner contracting with a contractor who's then contracting with subcontractors, and then off to the side, the owner will also be separately contracting with the consultant. And there's other documents or contracts the owner may have entered into with the consultant that, of course, are different than the CCDC2, and then the owner and the contractor enter into the CCDC2. In this format, the owner really has the design risk. The contractor has the design at the time it bids, and the contractor bears the construction risk because it's giving a stipulated sum price. And in terms of the document itself, the contract itself, the CCDC2, you're probably all familiar with it. If you're not, it basically, as I see it, has 4 areas. There's the agreement, the definitions, the general conditions, which are the CCDC2 general conditions, and then frequently there's supplementary conditions as well. So just sort of take the supplementary conditions, hive them off. They're not part of the standard form. And we're left with 3 things: the agreement, the definitions, and then the general conditions. The agreement, that's the part, the A pages, I call them. Those are that's the part where you fill in the specifics of your project, the parties, the price, things like that. Then there's the definitions. These are important to keep in mind. As I always say, that word doesn't mean what you think it means. And if you go to the definitions, you'll sometimes have a bit of a jaw drop where you say, oh gosh, the meaning of the word isn't exactly what I thought it was. So that section you have to keep in mind and refer back to. And then there's the general conditions. That's the guts of the contract. That's where the obligations are. That's where all the good stuff is. And that's what we're going to review in terms of where some things have changed, what things have been updated, and what new concepts have been added to the CCDC2. And just one thing to keep in mind as we go through what the committee, the CCDC committee, has in mind when drafting these. We're back. Hooray, Farron, gold star for you. So here are the three parts I was talking about. I've made my way over to the general conditions. These, remember, well, for people who don't know, the committee's trying, when it puts these together, to have sort of a balanced approach to the contract. There's people from all parts of the pyramid involved in the drafting. And when they're putting that in, they try to have a balanced approach. But of course, number one, it's not applicable to all projects. And also in different projects, the reality is different parts of the construction pyramid have different amounts of leverage or power or negotiating power. And so you have to keep in mind that these general conditions, as I mentioned, do get changed in the supplementary conditions. And you have to keep in mind that what is in the general conditions isn't necessarily what your contract says. Okay, so that takes care of sort of the introduction. Thanks for sticking with us during our technical difficulties. You have no idea how much we try to make that not happen and all of our backups, and then right out of the gate, we stumble. That's okay, we'll recover. All right, on to the next issue.
All right, so now I'm gonna talk a little bit about payment terms and the changes to the CCDC. While I'm getting to that slide, I'm gonna launch a poll and ask everybody, are your contracts up to date in terms of your payment terms? So there should be a poll, yes, no, maybe, you don't know, and I'll give you a few seconds as I get there. It's a tight race. Oh, it might be a three-way tie. Let's see. Oh, the numbers are still coming in. Interesting. So I'm going to end the poll, share the results. Yes, 42%, no, 25%, maybe 33%. So I'm hoping the maybe at least goes to a yes or a no at the end of today, and you figure out if you've done it. And you know, we're hoping some of the no's, you'll know what to do to get to yes. So payment terms. So the CCDC suite of contracts, you know, although Canada-wide now states that payment terms need to meet the requirements of payment legislation. Now, payment legislation is really only enforced in Ontario. It's the prompt payment regime found in the Construction Act, but it is making its way across the country at different stages and different speeds and a little bit different, but you know, that the idea of a payment legislation is coming through. The current CCDC2 does not address any of these issues. Obviously, it predates all of this new legislation. So, you know, if you're using your CCDC2 2008 right now, parts of it would be completely overridden by the Construction Act. Even if you agree to supplementary conditions that you've used for years, they still would be overridden, parts of them potentially, by the Construction Act. So this new CCDC 2020 seems to adopt some of the high-level principles from the Ontario sort of prompt payment regime, even though the legislation might not apply if you're not in Ontario. You know, one of the biggest things is we're seeing a shift in responsibility and maybe a little bit more risk to the owner. You know, as a litigator, I can say when I'm acting for contractors, there was a history of the owner sort of at times hiding behind the consultant and using that to potentially delay decision on payments or payments. You know, we'd hear the consultant's reviewing it. Don't worry, we're on it. We'll get back to you. And so you see a bit of that eroding through prompt payment legislation and also this new CCDC2 2020. So, you know, what is prompt payment? You know, I'm not going to bore you for 3 hours. I could, if you're interested, call me. We can set up a webinar, but I'm not going to do that today. But what I'm going to tell you about is a little bit about what it is. So prompt payment, the purpose of prompt payment is to get people paid quickly through the construction pyramid, and everything starts with a proper invoice. And so everything flows from this, and that includes timing of payments, which is 28 days from the owner getting the proper invoice. And then contractors and subcontractors have to pay, like the contractors have to pay their subs within 7 days of getting paid, and subcontractors have to pay their subs within 7 days of getting paid. So it's lightning speed compared to pre-prompt payment. Notices of non-payment, the owner has to give within 14 days of getting the proper invoice to their contractors. And not only do they have to say, we're not paying you, but they also have to say why, which is really fast. And those reasons are really important. Adjudication and some dispute resolution can be tied to prompt payment and the proper invoice. Now, this sounds simple, but it's really not. Like I said, Jeff, Krista, and I could talk about this for like hours and hours, but gives you a sense of what it is. And you can check out our sponsors software if you want to get a better understanding. But to tie this to the CCDC 2020, it's a couple of key changes. So one, we have to comply with whatever prompt payment legislation you have. Two, pay-apps have to go to the consultant and the owner. Again, the owner can't be sort of blind to what's going on. They have to know, and they're going to get that pay application directly. The owner needs to notify the contractor if there's an issue with the pay application, again, like prompt payment. And this is taken off the shoulders of the consultant and put a little bit more on the owner. Although I'm sure Jeff will tell you that owners are forcing consultants to give them the information, but at least it's involving the owner more in the process. Owners need to pay within 28 days or whatever prompt payment legislation applies in the province. One of the differences is that the contractor has to provide a statutory declaration and WSIB clearance certificate. Now, I know a bunch of you are saying, Farron, come on, this is like the most basic thing. Of course, we're going to need that. But it's not included in prompt payment legislation. It may not be included in your contract. And if it's not there, even though it's, standard process, according to Ontario prompt payment legislation, a contractor could get paid without either of these things. So the CCDC2 is incorporating some of those sort of typical vanilla things that you'd always have in your contract. So this legislation, although these are big changes to payment terms, we're seeing from a lawyer's perspective, a lot of modifications made or clarifications made with respect to prompt payment in contracts. So, you can talk to Jeff about all of the changes that all of the parties are making to these. So, I expect that you'd have some changes in your supplementary conditions, even with the new CCDC 220, like what goes in the proper invoice, modified paid when paid clauses, and all sorts of other stuff. So important to know what it is, but also always keep an eye out for those supplementary conditions and how payment terms might be affected by it. All right, I'm moving over to the next topic, which is safety. Jeff, over to you.
Okay, thanks, Farron. So just a small change, small but important change that from this that the CCDC has made in the new 2020 document compared to the 2008 version. So essentially what they've done is they deleted an old clause that was in the 2008 version, which basically stated that if the owner brings any other contractors onto site, then the owner became effectively responsible for occupational health and safety on site. So this clause was repeatedly modified by owners in supplementary conditions. It's typically deleted entirely. Because in most cases, in most projects, owners do indeed bring on other contractors onto site, such as an FF&E contractor or maybe an audiovisual contractor, somebody, especially near the end of the project. They're bringing on contractors that are directly retained by them and they're not subcontracted to the general. So this was a very problematic clause for owners. It was continually deleted throughout supplementary conditions. So the CCDC has addressed that in this new provision by basically making it so that the contractor remains responsible for health and safety on site, even if the owner is bringing on other contractors. But it's important to remember that both parties are still required to comply with, the Occupational Health and Safety Act and its regulations. And the owner also has to ensure that if it is bringing on these other contractors, that it needs to make sure they comply with the contractor's directions with respect to health and safety. So that is a requirement on the owner. And that's very important for owners. They need to, make sure that their agreements with these other contractors spell that out and have them basically acknowledging that the general contractor is in charge of health and safety. But that's an important change just because it's, it's something now you don't have to look forward to in the supplementary conditions. And so the next key topic is ready for takeover. So I'll pass that over to you, Krista.
Thanks, Jeff. So ready for takeover and early occupancy sort of go together. These concepts are new to the agreement, and ready for takeover is a concept that sort of replaces the previous concept of substantial performance. So Farron, if you can just go forward one slide. Did this break as soon as I started again? This
I'm just gonna say, I think it's you. For the record,
it's fine. It's fine because I'm the best at ad-libbing. So okay. Sorry again for the mess up in Zoom. Farron will solve our problem. Basically, before the changes, there was this concept of substantial performance, and it appeared sort of in two places. It appeared in the CCDC too, and it also appears and comes from the Construction Act, the construction legislation. And there was, they were kind of together. The CCDC was using the term, but there was sort of a misalignment in terms of exactly how the two concepts worked. And it wasn't perfect in terms of a contract milestone. Thank you, Farron. It wasn't perfect in terms of a contract milestone. So rather than try and take substantial performance and modify it and say substantial performance, but this and that, and create confusion with the term, which is really a legislative term, there's a new term of ready for takeover, which is the contract milestone. And that's kind of scattered, throughout the document where it matters for the contract milestone. You would frequently before see that owners particularly would want additional deliverables for added on to substantial performance as it's sort of set out in the act. So this isn't surprising that there'd be a change for this. Substantial performance, keep in mind, it still exists, except it's not the contract term, it just exists in the legislation. So it's still there in the legislation, but now it's kind of a contract. It's not a contract term anymore. So ready for takeover, it's a contract idea, it's a contractual milestone. It's not related to liens, that's still substantial performance, and it's tied to obligations we'll get into in terms of completion, such as warranties, insurance, indemnities, things like that. Okay, Farron, I tricked you. Now you can go ahead. All right, so what are the requirements for ready for takeover? So the CCDC2 actually sets out some requirements for that. And here's a list we put together. Just a few I'll highlight. I won't go through all of them one by one, but you'll see in number one that substantial performance itself, which is that the legislative definition, that is one of the requirements as certified or verified by the consultant. So it's still relevant to this. And then an occupancy permit by the authority having jurisdiction, that's also required. And then if you look down in number 7, you'll see owner has been provided ability to secure access to the work. That's sort of, I think, keys really is an easy way of saying that. And then you'll see some of these things are if as required by the contract document. So they're not necessarily applicable in all instances, but substantial performance and an occupancy permit are things that are required. Okay, so moving to the next section, there is an idea in 12.1.2, I call it sort of the get out of jail for contractors. If there's certain things that cannot be achieved and ready for takeover can still be obtained if these things are outside of the control of the contractor. So for these things that we've put in bold, it may still be possible to obtain ready for takeover without those particular items. Okay, so moving on to early occupancy. Early occupancy is a concept that allows the owner to get into the space, most often part of the space, although it could be all of the space, but usually part of the space early. And the preconditions are written there. The contractor must agree and there must be approval from the authority having jurisdiction. So in other words, you can't flout occupancy laws or safety laws in the jurisdiction. But the more interesting one is that the contractor must agree. And then what's really interesting about that is the part in brackets, which is acting reasonably. So this concept of early occupancy, it does still require an agreement, but the contractor doesn't really have complete power over this issue because the contractor does have to act reasonably in deciding whether to give that early occupancy. And then if the owner does occupy part of the work, then there are some consequences to that. And the part that the owner takes over, that's deemed to then have to be ready for takeover. And there's certain things that flow from that ready for takeover, including warranties and care of that part of the project. And one thing that's interesting that the CCDC2 doesn't address and may have to be addressed more clearly in supplementary conditions is what happens to the parts of the project that then both the contractor and the owner will be using. And so you should give some thought to that. If there is going to be early occupancy or you think that's likely, then give some thought to how you want to address those issues, those parts that both the contractor and the owner will be using. And really this is trying to create, again, as the CCDC does, tries to create a balance between the parties in terms of what's reasonable. Okay, so that is early occupancy. And on to the next issue.
Right, we're on to indemnification and waiver. And I'll say, I know for most of you listening to this is when you enter into a contract, you are not thinking about indemnity and waiver. You are not concerned about it. It's not about the deal or getting the job. But I can say as a litigator, it's really important that you at least understand and know what you're agreeing to, because it really can impact your future claims and issues. And I hope you never have them. I mean, if you do, we're happy to help you with them. But in the event that you do, you really can limit what you're able to claim based on these provisions. So I urge you to just pay a little bit of attention to them and at least know what you're agreeing to. So, it's important to understand how it can impact your project, and I hope you never have to use them. But timing of your indemnification is now tied to this ready for takeover instead of substantial performance. It's, tied to a different stage of the project and probably makes more business sense as to when, the indemnification and waiver period should start. There are limits on the types of indemnification provided. So, there is for direct loss and damages, but it does not include indirect, consequential, punitive, exemplary damages. Now, I'm going to give you a horrible lawyer's answer. What do all of those mean, Farron? Case law isn't entirely clear what exactly all of these things are. So, another thing to think about is you might want to spell that out in a little more detail, but I'll give you an example. Things like loss of profits are generally categorized in these consequential type damages. So, if you want clarity on what's included and not included, using the words in the CCDC 2020, I think might be vague and you might have to fight about it later on. It's probably cheaper and easier to define them in your supplementary conditions early on, so that, if you get to that point, it's clear what the parties have agreed to. Other changes are you have to indemnify for third-party claims without limit, and there are still monetary caps on indemnity claims. So, how much, again, something that you're going to want to look at is how much do you want that cap to be for? And you might want it to match, for example, potentially some insurance that you have, and or some other number. But I use insurance because that's where we're going to next. And I'm going to we're going to turn it over to Jamie to talk a little bit about the changes to insurance in this new CCDC 2020 part. So over to you, Jamie.
What I'm going to be talking about today is the insurance changes under the new CCDC. But what I want to start with is to make it clear that under the GC 11.1 section of the CCDC contracts, what it actually refers to is the CCDC 41 insurance requirements publication. Is that better before I go on? Yeah, I'm seeing some head nods. Okay. So that is this document here. We are going to send this around afterwards so everybody gets a copy of it. This was published on December 14th, 2020, okay? The CCDC GC 11.1 section actually refers to the most current version of this document that was in effect at the time of a bid. So whether you're bidding on a CCDC 2008 version or the new version that's just come out, these new insurance requirements are your new contractual requirements. And so there's a bit of a misconception there. And it took ourselves a minute to wrap our heads around that as well. We initially thought under the 2008 version, the old limits would apply, but that is not the case now moving forward, okay? So these limits, the new insurance limits, which I'm going to outline, are now in effect. Okay, so what we're going to talk about, first of all the new insurance requirements have been changed to make reference to the ready for takeover date, where they previously referenced the substantial performance, okay? So there's a major change then in terms of when your insurance requirements essentially need to be in place until. Specifically, that is important for the builder's risk aspect or the course of construction. That has been a requirement on the old CCDC, that's a requirement on the new CCDC. The new CCDC needs it to be in place until ready for takeover, and then an additional 10 days from that date. And there's a couple other options in there, but that's the main one. I want to point out here that that is the one coverage that we find contractors often miss and do not carry. It's a contractual requirement under the CCDC, old and new. Doesn't matter if you're doing bridge work, sewers, underground, new buildings, interior renovations, you are contractually required as a builder to purchase the builder's risk or course of construction coverages for your project. Second point here is they have gone and increased insurance limits for per-occurrence for general liability, automobile liability, manned aircraft, and watercraft liability from $5 million under the previous CCDC 41 to $10 million. So did we get the results of that poll, Farron? Okay, so it looks like the majority of you are carrying $5 million, which has been sort of the common requirement going back to 2008 when we saw this increase last time. So for all of you that are in that bucket or in the 2 million, you need to begin the process of increasing your insurance coverages to 10 million to meet these new CCDC requirements. And I'm going to talk about that a little bit more on the next slide. There's also a new unmanned aerial vehicle liability insurance requirement. It's a $5 million liability requirement. That has been written in specifically because of the increase in drone usage on construction sites. This is only required if there is going to be drones used on site, but it's important that you realize, like, if you're the prime contractor and you say, well, I don't have a drone, so that's not going to affect me, you need to make sure that your subtrades are also not going to have any drones on site. If one of your subtrades has a drone and there's any incident, you're going to be pulled into that issue. So we do sort of just highly recommend at this point that you look to carry this coverage if you're signing CCDCs, unless you're 100% clear that there won't be any unmanned aerial vehicles on site. And then there's a new contractor's pollution liability insurance requirement as well, in the amount of 5 million. We've started to see this one rolled out. It's been required by quite a few municipalities over the last few years. So this one's not completely new, but it is a new contractual requirement now under the CCDC 41. So we just jump to the next slide there, please. Okay, so I'm sure most of you have probably gone through an insurance purchase over the last year and a half, and have clearly at this point, most people realize what's going on in the insurance industry has been quite challenging. We're seeing lots of price increases and the contraction of terms. So these new limits are coming at a really challenging time, really for construction, the industry as a whole. It means that costs are going to increase for all contractors across all spectrums, unfortunately. We also expect that these insurance requirements, whether you're signing CCDC contracts or not in your class of work, these will become the new bar for the construction industry. It's not going to happen necessarily today, but we did see this in 2008, and we expect over the next 6 to 18 months, really these are going to be the requirements, and not just for prime contractors. We expect that subtrades are also going to have to increase limits because they will be asked by the general contractors to carry the same limits as they're carrying. So this will really affect all levels of the construction pyramid. What's going on in the construction world right now, and with the insurance market specifically, they're not overly aware of these requirements right now. We have started the process of increasing limits on auto specifically. That's been a bit challenging. Market capacity is limited. So our advice to you is to get on the phone with your broker as soon as possible. Begin the process of quoting these increased limits and adding these new coverages. At the very least, you can get some cost certainty around this process, so you can start carrying these costs in your bids moving forward, and then you combine these coverages as and when required. All right, thank you very much, and I'm going to pass that off to Krista.
We'll unmute myself, and then Farron, you can put up our poll, which is, what will go next wrong on this Zoom? Everybody vote. I'm only kidding. We didn't think to do that poll, but maybe we should have. Okay. Thank you, everyone, for sticking with us. There are some other changes, and I'm going to go through them. My colleagues, Jeff and Farron, said, well, these issues aren't that important. So, Christy, you can do them and take 2 minutes. So we're a little bit behind schedule, so I'll try not to take my 2 minutes for the least important part that my colleagues allocated to me in the presentation. I'm going to make them seem super important. Actually, this one, the review of contract documents, is important if you're a contractor. So this issue was always a big one of trying to shift risk for issues in the review of the contract documents, and the contractor being required to provide notification to the best of the contractor's knowledge, information, and belief about errors that they saw. So this has been stepped down so that now the contractor is only required to review the contract documents for this phrase, which is facilitating coordination and execution of the work. So lawyers love phrases like that because who the heck knows exactly what it means. But there is definitely a step down here in terms of the contractor's obligations. So that's one additional change. And then there's a bunch of other changes. We've put them up here on a slide of other changes. And the other changes, one thing that you may want to pay attention to that's interesting, Farron, we need to go ahead one more slide.
It's the curse of Krista. I'll be back.
Bingo for anyone who had the curse of Krista on their bingo card as the next error. So I will again ad lib. Good thing I'm good at this. So the other changes that you may want to look at, but they're not as big a deal. Farron talked about prompt payment. Of course, with prompt payment comes adjudication, and there's some information or contractual issues in there to make it clear that adjudication is this prescribed concept under the legislation, but it doesn't change the other dispute resolution processes that there are. Here we go. There's an issue of cash allowances and being able to take from one pot and put in the other pot to cover shortfalls. And the contract price is only adjusted if all of those allowances together exceed the contract amount. Some issues on change directives. We're not going to get into the details of those, but there are changes there. The big one probably for contractors, although there's some inclusions too that are clarified, is charging wages of personnel engaged in review of drawings. So keep that in mind. And then the stop work order, delays for stop work order, that actually is an interesting one. We're not going to go into it in detail, but there's no delay by a stop work order can entitle the contractor to a time extension. But only, of course, only if the ready for takeover cannot be achieved. Okay, so that's it for the sort of extra other changes. And we will move on to more interesting things that we've asked Jeff to deal with.
I'm going to just quickly talk
Farron,
about
sorry, go ahead.
It's okay. I'm going to deal with Division 1, and just for everyone, Krista's part is mostly over, so I'm hoping that the presentation will stay up for the rest of the time. I don't know what's going on today, but one of the things everyone needs to know about is Division 1, and it's interesting, you know, no one's really writing or talking about Division 1, and I haven't quite figured out why, because I think it's quite important to understand what it is and how it really changes what was going on with the CCDC 2008. So Division 1 is completely optional. It's not mandatory. It's not something you have to adopt. But if you think you're just going to start migrating over to the CCDC 2020 and sort of rely on a lot of the similar clauses in it, you will notice that a number of things have been taken out of the sort of the main general conditions of the CCDC 2008 and put into this Division 1. So if you don't want to use Division 1, you better make sure that in your supplementary conditions, you list some of these items. And, you know, to give you an example, things like cutting and patching, right? This Division 1 is sort of meant to be a sort of a bridge between the contract documents and specifications. So if you aren't going to use it, you're just going to want to make sure that your general conditions, or now your supplementary conditions, include these items. If you are going to include it, you must list it in the list of documents that you're relying on. It's not there automatically, so you have to make sure everyone knows it's a contract document. That's really important. And it's a Word document that can be edited, and, you know, which, you know, seems great because you can just sort of go in and type and change stuff. But, you know, from someone who reviews contracts, you know, it's a bit troubling, or, you know, a little bit more work, because, whereas when you have the supplementary conditions, I know exactly what words you've modified from the contract. I know you have to really review everything that's in Division 1 to make sure you understand the changes that were made. It's not like a track changes or, a modification. So you have to, if you are using the Division 1 route, please, please, please make sure you or your advisor reviews it in detail to make sure you understand what changes have been put into this document. And so like things that are in sort of Division 1, summary of work, contract assignments, work restriction, allowances, substitution procedures, the list goes on and on. Temporary utilities, cutting and patching I spoke about, cleaning and waste management. These are just some examples of what's in there. So again, just make sure if you're not going to use Division 1, make sure you've covered it in your supplementary conditions. And if you are going to use it, it sets out a whole, a wider range than what was originally in the CCDC 2 2008. So I'm going to turn it over to Jeff to talk about what you really need to be thinking about.
So just quickly, I just want to quickly talk about the supplementary conditions themselves and what we can expect going forward, because certainly one of the hopes behind the CCDC organization's efforts to update the CCDC to 2020 was to kind of make it slim, trim down, migrate some stuff over to Division 1, as Farron already mentioned, and hopefully reduce the need for supplementary conditions. Recently in the market over the past few years, the size of supplementary conditions, I'm sure some of you are aware of this, and have seen many of these, they've just ballooned, and it's not uncommon now to see supplementary conditions that are 50 or 70 pages long, almost twice the length of the actual contract they're modifying. So there was a hope and an effort to try and reduce some of the need for owners to be going in and drafting these really complex supplementary conditions. So they did that to some extent, but ultimately the changes just didn't really go far enough, I think, from owners' perspective. So certain things like early occupancy and changes to the safety provisions that I mentioned earlier, those certainly reduce the need for supplementary conditions, because those were concepts that were repeatedly added by way of supplementary conditions. But on the whole, I think you can definitely expect to continue seeing supplementary conditions going forward. You can see here on the screen just a list of things that the CCDC document just doesn't in any way address, which I think you're still going to see owners using supplementary conditions to include. So things like, enhanced schedule obligations. So, an obligation to provide a recovery schedule if you're delayed, or what are the procedures for submitting proper invoices? What are the additional requirements for your proper invoices? Who do you send them to? Clauses obligating the contractor to remove construction liens from title, liquidated damages if that's relevant. And then, of course, provisions dealing with kind of unique and specific risks. So things like COVID-19, obviously, right? How are additional costs and delay associated with the pandemic, or how are they going to be dealt with in the contract? A lot of people have now started over the past few months actually spelling that out in supplementary conditions. And also the new excess soil regulation. So this is the new regulation, if you're not familiar with it, that was introduced on January 1st of this year, and it just has absolutely sweeping, very, very significant impacts to all construction projects really that are dealing with any sort of management or removal of soil. So if you're dealing with excavation, this regulation now has some pretty significant implications. So I think you're going to see a lot of supplementary conditions, or at least a lot of additional contract documents dealing specifically with that regulation. So all of which is to say, I think you can still definitely expect to see supplementary conditions going forward. And lastly, next slide, Farron. So lastly, we just wanted to leave you with, before we jump into some questions, we just wanted to leave you with some best practices when it comes to managing your contracts and getting them reviewed and updated. So now, as construction lawyers, Farron, Krista, and I, we see a lot of disputes, obviously, and a lot of them could have been avoided if the contract had been carefully reviewed and updated beforehand, or at least your position, in a mediation or in an arbitration or in court could have been significantly improved if some simple mistakes had been avoided. So some of the most common things we see, number one would be failing to list and describe the contract documents. In my view, this is by far the biggest problem that's plaguing the construction industry right now. And it can have really significant consequences. So if you don't include a document in the list of contract documents, it does not form part of your agreement, right? And so this is critically important to understand. It's that little box that you can fill in it's Article 3 in the CCDC2, and you just want to make sure that any additional documents are inserted there, right? So does your bid or your quotation, does that need to go in there? What about RFP or tender documents? Should they be listed there? Maybe there were some exclusions or clarifications you made with the owner during the tender period, right? With respect to maybe price or your scope of work or something like that. You want to make sure, even if that's captured in an email, you want to make sure that's listed there as well, because that's kind of the four corners of your contract. So that's very important. Failing to flow down all of the risk and obligations under the prime contract onto your subcontractors. This is a common problem we see general contractors making a lot. Now, many subcontracts do have broad provisions that will just kind of generically reference the prime contract. The CCA1 standard subcontract, for example, does have such a clause. But it's important to know that that may not actually be enough in certain circumstances. So you should consider adding some additional express language, particularly for some discrete or impactful provisions, right? Things dealing with liquidated damages or something like the new excess soil regulations. We've seen courts in the past actually find that those types of broad clauses that simply refer to the prime contract weren't enough to sufficiently flow down all, a specific obligation onto a subcontractor. Also assuming, inappropriate or improper risk is another common mistake we see. And again, it's hard because the contracts and supplementary conditions have become so large that you may not appreciate the extent of the risk you're seeing. So, or the risk you're assuming. So, common problem areas I see probably once a week in supplementary conditions are to do with site conditions. That's a main one. So it's become very common in the market now for owners to add clauses that basically say the contractor is essentially presumed to have done a thorough investigation of the site, and they assume all the conditions, all the site conditions that could have been discovered during such an investigation. That's become extremely common, and it's being promoted by a lot of people who are advising owners. The problem with that is in many cases you weren't actually given an opportunity to do a thorough site investigation, right? You didn't get to analyze the soil or look behind walls or above ceilings or below floors. But with a clause like that, and it could just be a couple sentences, you could inadvertently be taking on the risk for those types of conditions. And it's also very common in the market right now to see owners including fairly heavily modified indemnification provisions. So Farron talked about the indemnity clause in the CCDC2, which is now GC 13.1. But owners, again, very frequently will modify this and replace it basically with a clause that is typically shorter. But what it essentially has the contractor agreeing to is to indemnify not only the owner, but various third parties like consultants, other contractors, maybe the landlord or the tenant, and the owner's agents, right? These kind of amorphous third parties that nobody knows who they are. And they also frequently remove the monetary caps that the CCDC includes on the indemnity provisions, which are in GC 13.1.2. So look for that as well, because the effect of that is basically the contractors assuming unlimited liability, including for those very scary kind of consequential damages like lost profits and all of that stuff. And also failing to review and comply with notice requirements. I mean, that goes without saying, but it is critically important. The CCDC has its own notice requirements. For example, there's a requirement to notify the owner of any delays within 10 days. And owners will frequently, either shorten those deadlines or increase the content requirements for those types of notices. So you just want to make sure your project team's aware of them, flag them and make sure you're complying with them. So lastly, those are kind of the common mistakes we see. And what are some of the best practices to avoid some of that? Next slide, Farron. So this is kind of a really high level 80-20 rule for dealing with some very simple kind of low effort things you can do to really minimize your risk and avoid some of those mistakes. So one thing obviously is to, carefully review the contract, the proposed form of contract and the supplementary conditions. Hopefully they've been made available by the owner during the RFP or the tender. If they aren't, consider issuing an RFI and asking for that so you can actually review them, because that's critically important to understand when you're preparing your bid. And also, understand, are the contract terms up for negotiation, right? Owners often, this is often unclear in the RFP or the tender, whether you actually you're forced to agree to these supplementary conditions or if you're actually allowed to push back on them. So if it's unclear, I would also, again, recommend asking during the procurement, get clarity from that on the owner. And identify red flags, obviously, right? So, flip to the indemnity section, see what they're doing there, GC 13.1. Did they remove the indemnity caps? That's 13.1.2. You look for anything to do with site conditions or site investigations and consider, is that, is what's being asked reasonable in the circumstances? And also for contractors, it's important to develop a good standard form of subcontract that's properly managing your risk, right? Now, if you're using the CCA1 standard form subcontract, that's a good contract. It reads well with the CCDC contracts, but you would still want some supplementary conditions there. There are some onerous clauses on the contractor in the CCA1, such as Article 6 that's dealing with payment. It has some pretty draconian steps that the contractor is forced to take if it doesn't receive payment from the owner, including registering a lien and stopping work. So those are the types of things you'd want to amend. You'd want to consider adding some additional language that expressly flows down some of those discrete provisions that are dealing with, significant areas of risk, as I mentioned before. And also, you'd want to look at things like what are the claim provisions? Are the deadlines for filing notices to me the same as the deadlines that I'm subject to in my prime contract? I often see that as a problem too, where the subcontractor has a longer period of time to notify the contractor of things like delays or unforeseen conditions. And that time period is longer than what the contractor has to notify the owner under its prime contract. So you want to make sure those things line up. And lastly, it's also just important to know when to get advice, right? In terms of insurance, Jamie already mentioned this, right at the beginning of the procurement period, that's when you want to, send the insurance terms off to your broker to get them reviewed. And supplementary conditions, they're often modifying the standard form insurance provisions. So that's something you don't want to leave till the last minute. And, the time for getting someone like a lawyer or anyone else looking at your contracts or training your staff or your estimating team on what to look out for in supplementary conditions is now, right? It's not after the fact once you get into a dispute. And the cost of doing that really is nominal compared to the cost of, litigation or arbitration. So, those are some of the important steps I think you could take. And, having someone review your contract and making sure you have really good supplementary conditions, that's not enough. Obviously, you still have to construct the building and comply with your obligations, but it can really take you a far way down that road to ensure that you're not assuming needless risk. And I think that's really the emphasis here is it's trying to avoid needless, unnecessary risk. So that I think that does it for the topics here. And I think now we have some time to answer some questions that have come in.
Perfect. Thanks, Jeff. Appreciate it. And appreciate everybody bearing with the technical difficulties and particularly the panelists for dealing with those with some grace and some humor. The joys of working from home during a pandemic, I guess. What I will clarify for everybody is that we will share a copy of this presentation with all attendees afterwards, including the contact information for the panelists. So that will come out in an email in the next couple of days. And good news is we have a bunch of questions. And so I'll just jump right into those, just being aware of everybody's time. So first off, the question is, does the new safety clause contradict the definition of constructor that is defined in the new Occupational Health and Safety Act?
Well, yeah, I can address that one, Andrew. It's not necessarily that it conflicts with it. The definition of constructor is its own thing in the Occupational Health and Safety Act. So it has its own definition. It's and you know, but this is one of the problems, is that the statute doesn't expressly talk about, it doesn't really get into the weeds. It just talks about who's generally responsible for the project, right? So what's really important, you know, and what you would want to show if somebody like Ministry of Labor ever showed up on site, is that we have contractually, we're all on the same page on this project, right? So what I typically recommend owners doing in their supplementary conditions is, you know, just, and this is what I used to recommend historically before the changes were made, was spelling out, okay, the contractor is responsible for health and safety on site. And that's regardless of whether I, as the owner, bring on other contractors. But I will, you know, in my capacity as owner, any other agreements I enter into, I will make sure those contractors comply with, you know, the general contractor's directions for occupational health and safety. So if anything, the new CCDC to 2020 actually gets us closer to where you want to be in terms of the statute in Ontario. So no, I wouldn't say it's necessarily in conflict with it.
Thanks, Jeff. The next question is it's a bit more of a prompt payment question, but where an owner doesn't provide the prescribed notice of non-payment on time, what is the effect, if any, on the owner's claim for alleged deficiencies or incomplete work?
So it depends on what the contract says, but in terms of prompt payment itself, if an owner does not give that notice within 14 days, the contractor is entitled to the payment and can go to this adjudication process. And, we haven't seen a lot of these adjudications happen, but we suspect the adjudicator will say, if you didn't comply and provide that notice, the contractor gets paid. Now, some of the contracts that we see drafted do allow for, if payments made, it doesn't mean that the owner agrees that the work is done, but it does make the money flow and have the owner sort of fight to claw it back if they don't give that notice on time.
Thanks, Karen. That's great. The next question is, if the GC is made responsible for all trades, including owner trades within this contract, does this align with the MOL and WSIB expectations? Would they not prevail?
Yeah, so that's similar to the last question. So just to be clear, the contractor isn't made responsible for the owner's other contractors on site. All it's saying is they're responsible for health, just with respect to health and safety, right? They're in charge. So again, it comes back to, it's really on the owner. The owner, if the owner's going to bring on other contractors onto the site, they want to avoid being placed inadvertently in the position of constructor. So they need to make sure, and they have an obligation under the CCDC to do this, they need to make sure that any of their agreements with those other contractors include language that basically says, you have to follow the directions of the general contractor when it comes to health and safety, right? And that's just necessary because the general contractor doesn't have privity of contract with those other contractors. So it's really something the owner wants to make sure they're doing in their other agreements to make sure they follow their directions. But it's just to do with health and safety, right? And coordination in that respect.
Thanks, Jeff. This one I think is for Jamie. Do the new insurance requirements apply only to the new CCDC2 contract, or do these also apply to the CCDC2 2008 contract as well?
Okay, before I answer that, can everybody hear me?
Yeah, as close to your mic as you can, because there was some feedback that they were still having trouble hearing you.
Getting a real close up of me, but okay. So I tried to answer that in the presentation, but it might not have been that clear. The CCDC 41 insurance requirements are referenced in both the CCDC 2008 and 2020 documents, and it specifically references the most current version of the CCDC 41. I believe it's also referenced in the CCDC 4, the 5B, and the 14, and potentially some others as well. So double check whatever type of contracts you guys are signing and see where it's referenced there. But yeah, what I was trying to explain earlier is that these new insurance requirements, specifically the new coverages and the increased limits, will apply effective essentially immediately, going back to December 14th. Whether you're signing a new CCDC 2 2020 or an old CCDC 2 2008 contract this year.
Perfect. Thanks, Jamie. Appreciate the clarification. The next question. In general, is it correct to say that the ready for takeover model is effectively taking over substantial completion as the final milestone? And can you please confirm whether there is any way for owners to challenge projects as being ready for takeover?
So I'll jump in on that one. I think in a way, I mean, the answer to your question is yes, in the way you're thinking of it, I believe. But in the way I think of it, there's sort of two issues, and they're separate. There's the contractual final milestone, and that's separate and apart from the legislation that deals with liens and holdback. So for the purpose of holdback, for the purpose of liens, ready for takeover isn't something you look to, and it's not a final milestone for that. But for your contractual issues, it's the sort of final milestone. Yeah. And in terms of a way for owners to challenge the projects as being ready, so this is something that you can contract for. So it's a contractual issue, not a legislated issue. So whatever you want to make as the way to challenge projects as being ready for takeover, you can put into your contract, because this is, and you can change it in the supplementary conditions. So the general conditions for the CC that are already in the CCDC2 were the ones we showed you, and then that can be modified in supplementary conditions. And of course, if there's nothing there, there's always just a general dispute, a contract dispute that parties can get into about whether or not it's been achieved. Hopefully that's not where you go, but it would be disputed like a contract would in the normal course. Farron, Jeff, do you have anything you want to add? Okay.
Yeah, no, I think that's right. I think, yeah, the CCDC really wanted to, as Krista said, it's really trying to shift away from trying to shoehorn in the owner's desire to have these various completion requirements that it wants to put in its contract. They were trying to shoehorn this into the definition of substantial performance, and that just doesn't work because it's a legislative definition. So dividing those two concepts out really does make sense, and ready for takeover really now is kind of the more key important milestone, apart from liens and holdback, as which will still of course be all subject to the Construction Act and substantial performance.
Thanks, Jeff. Thanks, Krista. There's just a quick question on the insurance requirements. Is this applicable for cranes as well? I can sort of knock that off quickly. So if cranes are used on site, they would be covered under the liability coverage of the contractor. We'll move on to the next question. If the new CCDC 41 is to be used for old CCDC 2008 contracts, then how do you handle the reference to RFT clause that is in the CCDC 41 but not in the CCDC 2?
That actually is not referenced in the CCDC 41. The CCDC 41 just outlines the insurance limits that are required and the various coverages. The ready for takeover is referenced specifically in the CCDC 2, section 13.1. So if you're on the older version, it would still follow the substantial completion model.
Perfect. Thanks, Jamie. A couple more questions here. If there's no negotiation allowed on any of the supplemental conditions, is that reasonable and or legally enforceable?
So it's a great question. So I'll jump in first, and then I'll let Jeff or Farron jump in as well. So yes, that's fine, as long as somebody's not breaching the mandatory provisions of the Construction Act. Then it's a matter of negotiating power. So there are, when it comes to holdback and liens, it doesn't matter what anyone with any amount of power wants to put in the contract, because those are mandatory. But if you're dealing with somebody, an owner in particular, who has a lot of bargaining power and can say take it or leave it, then really the issue is whether or not you want to take it or leave it, whether or not it's a contract or a risk that you want to take. And it's very hard to say downstream, well, I didn't have a chance to negotiate. Any tips, Jeff, on how to negotiate around take it or leave it?
No, I mean, this is an issue. This is a live problem in the industry, in my view. I think owners too frequently phrase it as take it or leave it. And that creates problems. I think owners need to think really carefully if they're going to make supplementary conditions mandatory as part of the, that you have to sign off on them as part of your bid submission. I would only be comfortable doing that if the supplementary conditions were very, very mild and tame, because you can inadvertently scare contractors off. If you put in some really hefty liquidated damages clause, but then you say the supplementary conditions can't be negotiated, then you're going to lose out on some bidders probably. So it's a challenging issue. The only tip I would say is just when it's unclear. I've seen that a lot, where it's the RFP or the tender document, usually in the case of an RFP, the terms it's not really clearly worded whether, we have to sign off on these supplementary conditions, right? They may use language like, and the proposed form of contract we're going to enter into is, the Ccdc 5B, but then they include as a schedule of supplementary conditions. So you're kind of left wondering, do I have to accept these supplementary conditions, or can I negotiate them after I get selected as the preferred proponent? So my recommendation is to try to get clarity on that early on in the process, right? Ask the owner for clarification.
And then another issue, of course, is that risk is cost, risk is price. So if you have an owner that's, saying take it or leave it, then you can usually price that risk into the job and see if it works. And if you're an owner who is taking a take it or leave it approach, then you have to consider that you may not, as Jeff said, you're leaving out some bidders, and more, I guess, precisely, when you're leaving out some bidders, you may also not be getting the price you want. And so you should be thinking about whether or not you want to take that approach, even if you have the power to take it.
Perfect. Thanks. Just a quick clarification question on allowances. So reallocation of allowances is or is not permitted. That point was just missed by one of the.
Yeah, sorry, that's the part I went through really fast in a panic. So thanks for giving me more airtime on that. And I swear I didn't plant the question. The reallocation of allowances is now permitted. So as a result, an increase in the contract price only occurs when the actual cost under all the cash allowances exceeds the amount of all cash allowances under the contract.
Perfect. Just a follow-up on the WSIB question earlier. Can you confirm who is responsible in the event of an owner subcontractor injury?
Yeah, Jeff, do you want to answer that from the point of view of a personal injury lawyer or a workplace injury lawyer or
Right.
a construction lawyer?
Let me get out my books from law school.
Yeah, so I'll tell you, from in the event of an injury, everyone's going to feel some feel some responsibility for that. But Jeff, go ahead. Sorry, I'm editorializing.
Well, no, so I think it comes down to, and again, this is a little bit outside our wheelhouse when it comes to occupational health and safety, but I think it would come down to the occupational health and safety legislation and the construction project regulation in particular. And I confess I'm not entirely sure the scope of the constructor's responsibilities for, how present they have to be. I think the requirements are fairly demanding and fairly stringent. But yes, just to be clear on the point about how the CCDC deals with health and safety, again, and I know it's a little confusing just because it's the CCDC 2008 said one thing, it was frequently modified by supplementary conditions to say another thing, and now the 2020 is saying it's something different. So what the 2020 says right now is the contractor is responsible for health and safety on site, right? So you can read that basically as saying they're going to be acting as the constructor under the Occupational Health and Safety Act. And that includes for other contractors, in quotations, which is now a defined term in the 2020. So they're acting as constructor, even though the owner may have some other contractors on site. So they do have that overall responsibility for health and safety, which again, 9 times out of 10, they did before, because owners just always modified the old 2008 CCDC provisions to say that. And that just makes sense. The general contractor is in the best position to act as constructor, right? The owner, like a school board, should not be acting as constructor on a construction project just because it brought in somebody to supply some audiovisual equipment. So it makes total sense that this is why the 2020 made this change. But again, I think that the concern is for owners, really, in my view. They need to make sure that their agreements with other contractors spell that out and say, look, you have to follow the directions of the general contractor. Because if they don't, there's a risk they can place themselves in the position of constructor under the statute.
Yeah, and there's also, maybe if I can just jump in to something to keep in mind, which is that we're talking about contractual obligations as between parties in the pyramid. And, a person who's on site and gets hurt, whether that's a worker or a subcontractor or worker that is part of the employee of the general contractor or whomever, they have other rights that are outside of the scope of the contract between the two parties that are negotiating in the CCDC too. So the actual person who gets injured isn't going to be limited. It's no response to that person to say, well, I contracted with the general contractor, so you go look to them. Really what the contract is doing is allocating risk between those parties, but it isn't binding on the person who gets hurt. Let's put it that way.
Okay, we got questions continuing to roll in. So can bidders combine to dispute or request change of supplementary conditions without collusion issues?
I have never seen an allegation of collusion or price fixing in that situation. I've also never really seen that happen in sort of parties that are actually not together, not bidding together as like subcontractors or something like that. It's an interesting issue. If you can find people to do it, I don't really see a problem with it in terms of shifting power to the other side. Jeff, have you ever actually seen that in a situation where there are sort of arm's length parties who are getting together?
Yeah, not exactly. The only thing I've seen a couple times, and I know this has happened, there are cases of this happening, all the way back to the 70s, I think, where construction associations will sometimes send around a notice to their members saying, watch out for this clause that this owner likes to put in its supplementary conditions, or even flagging a particular set of supplementary conditions for a particular project that the association doesn't like, and warn its members about that. Or I've even seen other associations basically encourage their members to include qualifications in their bids, saying like, to do with, I don't know, like wage escalation costs or something like that. So I've seen that happen. And I agree with Krista. I'm not sure it would necessarily be an issue of collusion. I think it's more, and you could maybe take that approach. It would be interesting. It will kind of go to the nature of the tender or the RFP and what the terms are. Because if you do provide some qualification like that, even if all of you do it together, there's a risk your bid is now non-compliant, right, with the terms of the tender, and so it could be rejected. But if you're willing to pass on that tender anyways, yeah, it's an interesting issue. But I've never formally seen that happen. But yeah, it's an interesting approach.
Thanks, Jeff. We have a question from Tennessee. I wish I was in Tennessee and out of the snow that we're getting here in Ontario. So enjoy it down there. This is more of a prompt payment question. I think sort of touches on sort of the groundswell in different provinces across Canada with prompt payment legislation and revamp of the different lien acts. The question is, it usually takes 60 to 90 days for subcontractors to get paid in Tennessee. Is that standard? So does someone want to just briefly maybe touch on payment in the context of Ontario's new Construction Lien Act?
Sure, I can jump in on that. I mean, is it standard? It's probably what normally happens in projects, but that doesn't mean what is supposed to happen. So, I think the reason we now have prompt payment in Ontario is to avoid situations where it was 60, 90, 180 plus. Now, if you're under the regime, so if the procurement or contract, whichever is earlier, started after October 1st, 2019, you're looking at subcontractors getting paid within 7 days of the contractor getting paid. And if not, the subcontractors do have the ability to dispute with the contractor that they weren't paid on time. So you see a big difference. The only exception is if the owner tells the contractor under our prompt payment regime that they aren't paying them, they give one of those notices of non-payment, then the contractor can tell the subcontractor, look, I'm not getting paid, but there is in one of the forms an undertaking that the contractor says, hey, you're not getting paid because I'm not getting paid, but I'm going to undertake to go and get that money from the owner. So, cool your horses, I'm on it. And it forces the contractor, in cases of non-payment where the contractor doesn't agree with the issue, to actually forces the contractor to go to the owner and get that payment. Because what we see happening a lot practically before this legislation is the contractor says, sorry, owner didn't pay me. I'm going to do what I can, but we have a paid when paid clause, paid if paid clause, and I'm not going to pay you right now. So we're seeing a big shift where the contractor has to actually take action and try to get that money as soon as possible.
Perfect. And there was just a quick follow-up on that. Does this mean that owners cannot change legislated prompt payment terms in the supplementary conditions of a specific contract?
Yeah, so they can be modified in the contract to help give further explanation. Like when I talked about that proper invoice, the requirements under the legislation are like date, amount, payable, who's payable, address, pretty basic stuff. So you can increase that with some exceptions. It can't be conditional on your consultant reviewing it, and it can't be based on owner approval. So there are definitely, we're seeing, and Jeff's doing a ton of tweaks to people's payment terms to deal with it, but you can't contract out of this whole, you can't say, well, it's not 7 days, it's 10 days. And I'm not going to pay you, owner's going to say the contractor, not 28 days, it's going to be more than that. So I think, there are ways to tweak it to make sense, asking for that WSIB or stat DAC, but you can't sort of rework the whole regime. Like Krista said, things like liens and holdback and all that stuff is is baked into the legislation and no one can change it no matter who they are. The sort of basic tenets of how it works.
Perfect. Just cognizant of time, so I'm just going to ask one more question, then I know Jamie's got a final point that he'd like to touch on. We will be sharing the presentation and the contact information, so if there is additional questions that people would like to ask, feel free to reach out to myself or one of the panelists. So the last question is, how quickly should we expect to see the new CCDC2 contract to become the new norm across the industry? And I guess that's a little bit of a crystal ball, but who wants to tackle that one?
I can give my best guess. I think it's going to be, I think probably in, around the middle of the year, I think you're really going to start seeing it kind of rolled out. I think the only delay will be while owners essentially get their supplementary conditions updated to align with the new legislation, the new contract. So, expect public owners like municipalities and cities are going to be working on that right now. So you still may see, kind of in the first quarter of 2021, we still may see the CCDC 2008 being used, and it can be used for the rest of 2021. So that's not a problem. But yeah, I think kind of probably around the middle of the year into the fall, it's going to become the new norm for sure. And then, of course, in the coming years, all the other CCDC contracts are going to be updated to have similar revisions. So this is definitely the direction things are headed.
Perfect. Jamie, final comment before we wrap it up?
Yeah, so I'll just add to what Jeff just said there. I do have one client that's already seen a new contract come out of Walmart. So it will move quick for some sophisticated owners. So just you could start to see it pretty quickly. And there's actually a question that Ray asked. It made me think a little bit about insurance and the sort of bid process and the open question period. You're going to see, because this is brand new and these insurance changes are going to lead to increased costs really across the board for anybody that's not already carrying all these coverages. You're going to see a mix of reactions from contractors. You're going to see those that just fall in line and go ahead and purchase these coverages now and increase their limits. And you're going to see those that decided to take sort of a wait and see approach to avoid incurring the cost right now. What's going to happen though at the tendering stage is you're going to have an expectation that owners are looking at the new insurance requirements, but that may not be the case depending on the sophistication of the owner. So it may be something that you want to question just to kind of make it clear to all bidders, especially if you're already carrying those coverages, to make sure it's an even and level playing field.
Perfect. Thanks, Jamie. So with that, we'll wrap it up for today. I'd just like to thank again the panelists from WeirFoulds and FCA. Typically, I'd be handing them a bottle of wine, but instead I'm giving them a virtual IOU for a bottle of wine or a lunch, perhaps. So thank you to the panelists. Thank you to the attendees. We appreciate you joining. The attendance was phenomenal. The questions were great. Again, we'll be sharing the slide deck with everybody in the coming days, along with the contact information for the panelists. So if you have additional questions, please don't hesitate to reach out, and stay safe and healthy out there. Thanks, everyone.
Thanks, everyone.
Thank you.
Thank you.
Thank you.
Bye.